In civil litigation, an affirmative defense is a defense that defeats the plaintiff's lawsuit even if the plaintiff's legal claims are genuine. So for instance, if the plaintiff has genuine legal claims but he files his lawsuit late, his lawsuit could be barred by the statute of limitations, or maybe he's filed his lawsuit in a court that lacks jurisdiction over the subject matter or the parties. There are many instances when a genuine lawsuit can be defeated by an affirmative defense. Now in Massachusetts, most affirmative defenses are waived by the defendant unless he asserts them in his initial answer to the plaintiff's complaint. So the plaintiff will file a complaint. This starts the lawsuit. A copy is served on the defendant, and the defendant has 20 days to answer the complaint. Now that is very, very early in a lawsuit, and often the defendant doesn't fully see all of the arguments he can make. So one of the things that most defense attorneys do is put all affirmative defenses or all common affirmative defenses in their answer to the complaint. Now, occasionally you'll get a plaintiff's lawyer who will use this to almost simply harass the defense attorney or the defendant. So you've listed a number of affirmative defenses, and during the discovery phase, certain plaintiff attorneys will ask for documentation and ask questions through interrogatories and depositions on why you're asserting these defenses and what grounds you have to make the assertions, etc. Now, one way to avoid this is to simply reserve all of your affirmative defenses, right? I've started doing this, and I have to say as a caveat, I have not had it challenged yet. I guess it could be challenged that a reservation of an affirmative defense is not an assertion of the defense, but I think most judges in most courthouses will allow the defendant to simply reserve his affirmative defenses. So I've written a blog post on this, and I will put it in the description below.